Conflict among the states was a major reason for the writing and adopting the Constitution. The Constitution strengthened the hand of the national government regarding commerce to help lessen, but in order to help lessen this conflict, several provisions were made that dealt directly with the states' relationship with one another. The Constitution states that no state can enter into any treaty, alliance, or confederation. However, the states, with the consent of Congress, may enter what are known as interstate compacts, which enable them to form agreements among themselves as well as with foreign states. One example of this is the Great Lakes Compact. The Great Lakes Compact is a legally binding interstate compact among the U.S. states of Illinois, Indiana, Michigan, Minnesota, New York, Ohio, Pennsylvania, and Wisconsin. The compact details how the states manage the use of the Great Lakes Basin's water supply. This compact or agreement was made between the two states and then went into effect when Congress gave its approval. The Constitution commands that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Public acts refers to laws of a state. Records refers to documents such as birth certificates, marriage licenses, deeds to property, and car registrations. Judicial proceedings relate to the outcome of court actions, damage awards, probating of wills, divorce decrees. The full faith and credit clause often comes most into play in matters of the court. For example, if Alan sues Bill in Florida, and a Florida court awards Alan $50,000, Bill cannot escape payment by moving to Georgia, because Alan can ask the Georgia courts to enforce the decision without having the case retried. Georgia's courts would have to give full faith and credit to the Florida court's decision. The full faith and credit clause enables a person to prove age, place of birth, marital status, title to property, or any other document a state would have in its records. There are two exceptions to the full faith and credit clause. The first one, it only applies to civil, not criminal matters. One state cannot enforce another state's criminal law. In addition, a state cannot grant a divorce to residents of another state. Extradition is the legal process by which a fugitive from justice in one state can be returned to the state where they are wanted. It is designed to prevent a person from escaping justice by fleeing to another state. Usually, extradition is a routine matter, where most governors regularly approve the extradition requests of other governors. But until the 1980s, governors could, and on occasion did, refuse to return fugitives. In the Supreme Court case Kentucky v. Denison in 1861, the Supreme Court ruled that the Constitution did not give the federal government any power to compel a governor to act in an extradition case. This case was overturned in the 1987 case Puerto Rico v. Branstad. In a unanimous decision, the court held that the federal courts can indeed order an unwilling governor to extradite a fugitive. Finally, the Privileges and Immunities Clause. This clause states that no state can draw unreasonable distinctions between its own residents and those persons who happen to live in other states. Each state must recognize the right of any American to travel in or become a resident of that state. It must allow a citizen, no matter where he or she lives, to use its courts, make contracts, buy, own, rent, or sell property, or marry within its borders. There are some exceptions, though, what we sometimes call reasonable discrimination. Any state can require that a person live within a state for a short period of time before they can vote or hold public office. A state can also require some period of time of residence before one can be licensed to practice law or medicine. A state can require non-residence fees to pay higher fees for fishing or hunting licenses. And as some of you may find out next year, state colleges and universities regularly set higher tuition for students from out-of-state students rather than those in-state.